Good morning, everyone. Welcome to our first hybrid employment law update and our first one for 2025. We'll get going in 5 minutes. We're just letting people who are online join, and people who have joined us in person come through. Just while we're waiting, there you'll see on screen there's a poll. If you could just go to menti.com on your browsers and type in the code displayed. It's just asking you to tell us what employment issues are keeping you and your team up at night. And we will be touching on all of them during the cases today. So we'll get going in 5 minutes. We'll just let everyone get online and come through. Thanks. See, online. See the polls slowly going up. I think we've got enough people, critical mass, inside the room and online to kick off. So just for those of you who have just joined, welcome again to our first employment law update for the year and our first hybrid one. We're just going to ask you to be a little bit patient with us. This is a trial for us. We're going to do a poll at the end to see to ask you for any improvements to the hybrid. But we really just want to give people an opportunity to come to be back in person. We moved it online during COVID, and we know there's a huge uptake on the online, people who join online, but we love seeing people in person. So welcome to everyone here and online. I'm Helen Wilsonach. I head up our employment and benefits practice, and I'm joined by some very familiar faces that I'll introduce to you as we go along. Just a bit of housekeeping. For those of you who have joined online, the chat function has been disabled, but you can pop questions in the Q&A, and we will try and address those as we go along. For those of you in person, we are going to make some time at the end of the session if you've got any questions. So if you've got any questions, just note them down, and then we can deal with those at the end of the update. As always, our session is going to be recorded. We'll put it on our website at the end of the session. And then Chloe will be doing her usual very helpful summary of all the cases. And those will be circulated early next week. So you can also just keep a lookout for those. So without further ado, we are going to kick off. I'm going to hand over to Talita Loebshow, who I think all of you are very familiar with, is an expert in many things, but including in discrimination law. And what we're going to start off with, before she gets into some of the interesting cases, is the status of the Employment Equity Amendment Act and the setting of sectoral targets. She's just going to take us to a bit of background about where things are with that. And then just now we'll check in on the poll and see what everyone's concerns are, but we're going to be touching on all those issues. Thanks, everyone, and welcome.
It is lovely to see you all here, and welcome also to our online audience. It is lovely to spend this time with you. Now, late last year, in December, the Department of Labor started sending out invitations to engagement with industry bodies and employers. And I'm curious to hear which of who you got some of those invitations to attend engagements with the department on the sectoral target. And did you attend and participate, and did you regard it as consultation? Which is your industry? Telecommunication. Excellent. Yeah. The feedback here is that there was consultation, that there was a lot of feedback given, actually a lot of questions, probably more questions than answers. Yeah, it was a very interesting time early this year when we came back and we started to engage with the department. Some organizations took the view that this wasn't true consultation. As you might be aware, some of the proposed targets were only shared a day or so before the meetings took place. Some were not even shared before the time, and employers were provided with the proposed targets in those meetings. So, yeah, there's also, I think, a question for the online group to indicate the sector that you are in, whether you received those invitations, whether you attended. If you can please complete that poll, please. So again, the targets were set as per the designated groups as a whole, like what we saw last year, and not per race and gender. And they differed from last year's target. And the Department of Labor explained that this was because they looked at the 2023, 2023 and 2024 target, or actually workforce profile, and that they then set the targets accordingly. In some of these sectoral engagement sessions, it transpired that what the department had done was look at the workforce profile for a specific level. And then they said, all right, these are sectoral targets over a 5-year period. We cannot give a target less than 1%. So we are going to give at least 1.25 or so percent over a 5-year period. And that then resulted in targets of about 6% for top management, if you look at the workforce profile for that particular area. In relation to the lower levels, the department said, no, we cannot give the same target for top management as what we are giving for senior management, skill, technical, professional, and so on. So they then applied the same principle of a target over the 5 years. So for top management, it is 6%, and then for each of the levels below that, it is 7, 8, and 9% from the 2024 workforce profile. There then was a very interesting development, and many of the organizations asked for bilaterals with the department, which took place. And we assisted some clients with those bilaterals. And one of the main concerns is that the targets are set for very broadly defined sectors. One example is manufacturing. Now you can imagine how diverse manufacturing is in South Africa. We are manufacturing medicine, we are manufacturing devices, cars, car parts, all kinds of manufacturing happens here. And yet everyone who's manufacturing is in one big sector. Another one is retail. We have a lot of different types of retail that's recognized actually by the SIC code. But we have, for example, food, we have clothing, we have motor vehicles, we have the entire aftermarket for the retail industry, motor retail industry. And yet the targets are set for that sector as a whole. So in the one bilateral that we attended, the question was, can the department please provide the workforce profiles for this specific subsector, which they then did. And what was very interesting from those numbers was that when you compare how they set the targets for the sector as a whole, as I mentioned, 6, 7, 8, 9%, it looked completely different when you looked at the subsector. So for example, there was for top management, instead of 6% target, there's a 14.1% target. For senior management, there's an 18.1%. For professionally qualified and middle management, it is 21.4%. And for skilled technical, 13%. So in the subsequent bilateral, this was explained to the department, and they took the view that this might be so. They are not going to revisit the manner in which the targets are set. They are not going to go back and set targets per subsector. These are the targets. And in order to allay fears, they were fain to emphasize that these are targets. They are not quota. They are aspirational. You need to show us that you are making progress. So that was a very important communication and confirmation by the department. You will remember that in order to get the certificate to do business with the state, you need to prove 3 things. The one is that you haven't had any judgments against you for unfair discrimination, that you are complying with the National Minimum Wage Act, and that you are complying with the target. When you are not able to comply with these aspirational targets, not quotas, the employer is entitled to put forward justifiable reasons. The regulations will set out what the department would regard as these justifiable reasons. I assume that that will be an open list, not a closed list, and that any proper operational justifiable reason will be considered in good faith. The department has not been able to give any indication of the types of evidence that would be acceptable. We have asked for that, and hopefully that will be in the regulation, but we are not sure about that. So in relation to timeline, the department is quite ambitious. They want everything in place by the 1st of September. They are saying the new reporting period is going to start then. Then employers should have already drafted new employment equity plans with reference to these new targets. So there's a lot of work to be done in that regard. And then everyone is going to be required to submit their baseline information. Everyone is going to get their certificate, and then from the year after, the next reporting period, then there is going to be assessments with respect to the progress in relation to the target. Any question? Any? Chris?
Sorry, Talita. So the targets are designated people as a block, you said, rather than specified by category. And are those rates of change? I assume, I'm sorry, I should know the answer. The rate of change would be, when you mentioned 6%, it must increase by 6% over the period.
Correct.
Okay.
Yeah, and it is for people from designated groups. But of course, the EAP is king.
And-
So what we would need to do is break it down per race and gender in our employment equity plan, because that is not changing. We still need to report per race and gender group.
But again, it's the rate of change. But is that a percentage of where you were when you started? Which means that if you start from a very low base, 6% is 6% shift from where you were.
It is not individualized. Chris. The
Right.
targets are per the 2024 workforce profiles for the sector as a whole. So for some, as I mentioned, it is not 6%, it is 14%. And it is not 7%, it is 18% or 21% for professionally qualified. So there is an argument, I think, that these are not rational and achievable for many of these subsectors. Whether we are going to see litigation in relation to these targets remains to be seen. It will be very interesting to see if there's any litigation, or whether employers are taking comfort in the fact that these are targets, not quotas, and that they will then give the justifiable reasons as and when it is required, and in the event of a case, a compliance order by the department, that they will then take that on and argue their case before the court. We will see how these organizations plan their litigation strategy. So I think the big thing now is we wait. We think that there is a high probability that the targets are going to be published very soon. Yeah, maybe at the end of this month. It will be interesting if they are published for public comment, which is actually what Section 15A requires. But there is also, of course, the possibility that the department will regard last year's publication as that publication for public comment, and that they will now publish the final targets. Whether that is the correct interpretation is also still being debated. So there's a lot of movement here, a lot of interesting times ahead. If I can just say what I always say in relation to employment equity plans, is make them as detailed as possible. In terms of Section 42, anyone considering compliance with the Act must consider your own plan. Explain your context. Explain where you get your candidates from, your pool of suitably qualified people. Another thing that's very important, that anyone, the court, the inspectorate, anyone assessing whether there is compliance must consider is the non-numerical measures that you are taking in order to improve the pool. If you have special programs aimed at ensuring that women are becoming engineers or are getting on-the-job training, put that in the plan. Explain these are our challenges, and explain what you are doing as an employer in your plan. Because that is what's going to be in front of a court or in front of an inspector. And all of us want people to have jobs. We want people to have skills to have jobs. So that is an important part of your employment equity plan.
Lisa, we've got a question online, if I can just read it for you and the people in the room. So Fatima's asked where the demographic population and the location of the business doesn't have a particular group, e.g. an EAP for provincial data shows 0.5%, etc. And or there are no communities from specific groups, will this then be considered as a reasonable justification? Fatima says inspectors for DG reviews don't seem to take this into account. think you're on mute. See, so what we're actually going to do is Komotso's going to give us our Lita Child's report. Komotso, thanks very much. And if anyone else has got questions about that, Lita will be here afterwards, so you can ask about the sectorial targets. Komotso, we can now kick off with our cases. We've got some very interesting cases crossing a whole broad range of things. In terms of the poll that we started off with, well, not interestingly, I think understandably, economic uncertainty came out on top as a thing that's keeping people awake at night. The sectoral targets was number 2, and then harassment is number 3. And we actually, Bowman's is going to be doing an harassment, a seminar both in Cape Town and Johannesburg in May, kind of looking at harassment through a different lens as an employer, how you deal with it. But moving on to the cases, Komotso is going to take us through a case dealing with strike violence and the impact on protected strikes, and that's the Bidvest case. Thanks, Komotso.
I think I've got a lapel mic. Morning, everyone. So I was told that I need to be fast and allow a few questions. So I'll present for about 6 minutes and then we'll have time for 1 or 2 questions. So as Helen said, I'm going to be talking to you about the Bidvest case. This was a decision of the Labour Court taken out of the Labour Court in Durban. And it involved NUMSA and RETUSA as the 2 unions. RETUSA joined NUMSA strike as a secondary strike. The strike initially was the notice was issued by NUMSA alone. So what I'm going to do is I'm going to tell you briefly what the case is about and tell you the conclusion, and then we'll just analyze the facts and what the judge said very quickly. The employees or the employer, being Bidvest, commenced a retrenchment exercise in terms of Section 189. And this exercise was facilitated by the CCMA. It was a facilitated process. This happened in December. And at the end of that facilitation, the employer issued notices of termination. So a lot of the people who were affected or terminated were NUMSA members. And in response to the notice of termination, NUMSA decided not to challenge the notices at the CCMA, but instead to obtain a certificate to be able to go on strike, which was very curious on its own. So on the 6th of December, the strike commenced. Now, at the heart of the issue before the judge was that there were 3 people who were shot and killed. And therefore, the employer went to court on an urgent basis to try and get the strike to be regarded or to be called to be unprotected, that it lost its protective nature. And the judge disagreed. So ultimately, the judge found that it was not permissible on the basis of the facts of this case for a strike to lose its protected nature. He said that the only way or the only time a strike may lose its protected nature, it's if the issue in demand had changed. He said that is the only time, that is the only premise. Now, let's just go back and look at a few, because when I looked at the summary initially before I read the case, I was like, okay, I don't know what is in there. But when you go into the facts, you start to question, I guess, the judge's conclusion and landing. Now, what is important here is, and Ross will love me for this because it's free marketing. It was very clear that Bidvest had no strike plan. They had no strike plan, and that was the first problem. They went to court and they were not prepared. They were not able to identify, in terms of the court papers, the perpetrators. They were not able to tell the judge that it was in fact NUMSA members who carried out the shooting or the deaths and the violence in general. But importantly as well, so there were 2 reliefs that they sought. One was to try and force the CCMA to issue picketing rules. The other was, as I said earlier, was to call this strike to be unprotected because of the violence. In the process of this matter being heard, the CCMA did issue the picketing rules, which then meant that relief fell away. So what was very interesting here as well is the judge's view in relation to the violence, or the judge's view and the conclusion he reached was less on the basis that there was no evidence before him that the people who perpetrated this act on NUMSA members, but he was not convinced that no matter how violent a strike may turn or become, that it may lose its protected nature. So curious about the deaths is that they happened at two of them at the same taxi rank, which is a bit removed from the employer's premises. The third one happened also at a training station, again, slightly far removed from the employer's premises. When I spoke about a strike plan, when you do have a proper strike plan, the moment you get a notice or the moment you hear of a threat of a strike, you set these things in motion. You get people who are going to be able to assess and help you to gather this fact, to make sure that by the time you have to go to court, because often it will be on an indigent basis, that you've got all the facts you need, including video cameras, statements, affidavits, and so on. So the employee here was not ready. And if you know how to prepare for a strike, yours faithfully, Ross, she has prepared what we call a strike kit that will take you from A to B, or A to Z in terms of what to do there. Now, the other assaults that were alleged to have taken place seems to have taken place just outside of the employer's premises. Remember, I said when this agent was launched, picketing rules had not been agreed, and therefore the CCMA had not ruled on picketing rules. So I think for about 15 days of the strike, there were no picketing rules, and therefore these employees they went anywhere and everywhere because NUMSA and the employer did not agree on these picketing rules. That ultimately did not become an issue that the judge had to determine, because by the time the matter was heard, I think it was the day before, the CCMA had issued picketing rules. But again, an important lesson there is to say, when there are no picketing rules, you must anticipate, particularly given the fact that a lot of strikes turn violent, that might be an issue, and you need to be ready. When the judge was considering the issue of agency, he then said, even though the picketing rule issue is not before me anymore, I want to comment on it to say, if the employer had come to me now, 15 days later, to seek to get an interdict for violence based on the lack of picketing rules, I would not have entertained this matter as an agent matter on that basis alone, because this will be self-created agency. So it is important in determining where the employer is situated, that you have a time frame of when can I legitimately approach the court on an agent basis to seek an interdict. Because one of the things that are interesting here is that part of the area where this port was, where the employer operated, was classified as national key areas, right? So it was one of the bases in which could have been used to reinforce picketing rules, or at least to approach the court on an agent basis. But the main essence of the case centered around the violence. As I said, the beginning was always a problem, that they didn't have evidence. There was a lot said in the papers in relation to the violence, but ultimately the employer was not able in the papers to point or to link the violence to any of the two unions. Just simply that there was violence and people have been threatened and so on. So what I want to do is, however, with the 2 minutes I have left, just to read you a few passages, which I think may help you understand why I think the judge may have not come to the right conclusion. So the judge refers in his judgment to judgment of the Labour Court, and a third judgment which quotes Professor Crawford. And he says, I disagree with these judgments simply because the conclusions they reached was not based on any legal authority, right? So he doesn't acknowledge that the judgment themselves are authority. And he says that because they do not quote themselves a prior judgment, then they are not authority. So therefore, they're not binding on you, right? That is what he says. And the first case we're going to look at is Tsoho-san. This you'll find in paragraph 31 of the judgment. He says the applicant relied on two decisions of this court in support of his assertion. And the first one is Tsoho-san. The quote from that judgment, it says, the court will always intervene to protect both the right to strike and the right to peaceful picketing. This is an integral part of the court's mandate conferred by the Constitution and the LRA. But the exercise of the right to strike is sullied and ultimately eclipsed when those who purport to exercise it engage in acts of gratuitous violence in order to achieve their ends. When the tyranny of the mob displaces the peaceful exercise of economic pressure as means to the end of the resolution of a labor dispute, one must question whether a strike continues to serve its purpose and thus whether it continues to enjoy its protected status. I guess in the interest of time, let me not read the other two cases and the professor's code. But in essence, what the judge then decides ultimately is, I'm not bound by these decisions. I'm not even persuaded by them. I think that because the employer did not allege before me that the nature of the demand changed, on that basis alone, the only way in which you can change a constitutional right is by law of general application, as we know. And therefore, he did not find that the right to life is one that can be considered also as one that falls within the limitations. So the judge ultimately finds that you can only call a strike to be unprotected if a party can show and prove that the demand has changed. So in this instance, it doesn't matter how egregious the violence is. It doesn't matter how many people die. Doesn't matter. That will never change that fact. And as I said, he doesn't rely on these cases because he says there was no authority for them. Now, two thoughts there. Really gave you a brief summary of this case. But two thoughts I have in relation to this decision. I think one, as I said earlier, part of the problem before the judge was there were papers which were long, but these papers were not proper simply because the background work was not done. They rushed to court. There were letters that were sent to the union. In those letters as well, they just make general accusations. There is violence, there is assaults. The union responded saying, well, we sympathize with you. And if you can point to us that it is our members, we will call them to order. But you haven't done so. At least on 3 occasions, this is the response. Even about the deaths, they say, no, this is unacceptable, the unions. And we need to call this out. But where this events happened and when they happened, we don't see how they're related or connected to the strike. So as I said, although the judge does not rely on that, I think that is important, that before you launch an application, you need to make sure that you've got the right information before you. The second is, I don't think if this decision is challenged, that it will withstand scrutiny. I think there is a general acceptance, at least from the few cases, that he himself quotes, that accept that if people call a strike and that strike is protected, but they then go out to try and achieve other means, which is either to commit assault or violence or to commit murder, and you can prove that, and you can prove that it was the union, I don't see how a reasonable judge will not come to the conclusion, as it was the case in Tsoho-san, that the nature of the strike had changed, and therefore the protected nature of the strike will also have to change. So I'm going to land it here for now and see if there are any questions from the floor. No questions.
Thanks
Okay.
so much, Komotso.
Thank you.
That's probably one of the cases that is less welcome to employers. And actually, we'll see in one of the cases a bit later that failure to put sufficient evidence before the court can turn what would be an otherwise good case into something with a very unwelcome outcome. And we're going to hear from Talita again on I think two cases that are very interesting. The first one is a constitutional court case on retirement age and on the rights of the employer to terminate an employment contract once someone has reach the retirement age. I think it's a case that we can safely say has caused more confusion than clarity. And I think was, given that some of the judges in the Constitutional Court are quite close to retirement themselves, was probably a case very close to their own hearts. So Talit will unpack that for us. And then the second case, pivoting a bit to retrenchments, had a genesis in COVID, which we all know was a very unusual set of circumstances, but I think gives some very interesting insight into what the court will regard as valid operational requirements, just how far you can stretch that concept. And Talita, if you don't mind, there was one more question on the chat that went back to the sectoral target. So Talita is just going to address that question and then we'll get straight onto the cases. Thanks.
Thanks, Helen. Yeah, the question was, if you have passed the EAP for a particular group, for example, for women, must you now, still go in accordance with the targets? Now, it is still very much unclear how you would extrapolate from these very broad designated group targets to get to your specific race and gender numbers. The department did say that they will address that in the final regulations. But as I mentioned earlier, the EAP is actually what you are working towards. So if you have exceeded your female target 50% or more, then even if the sectoral target is higher, then that would be in order. But yeah, we will need to see how the regulations deal with these mathematical problems. They say that old age is the most unexpected thing to happen to anyone. And that's true. You look in the mirror and you look like, you looked always. And then one morning you wake up and you're like, what? My child is now in high school. How did this happen? But that is actually what happened to our Chief Justice Zondo, I think, because in 1998, he wrote a judgment in Swatzer versus Wacko, in which he said that the Labour Relations Act is very clear. Once an employee has reached retirement age, the employer can rely on age to terminate that employment relationship at any time after the employee has reached that age. So if your retirement age is 65 and you happen to work past that age, at any point, can the employer tell you, it's time. We need to make space for younger people, new blood. You need to go. There needs to be that agreed age or a normal retirement age applicable to employees of that category. But that was the principle. Then, how many years after that? 26 years after that, came two cases. The one is Landman versus Great South Panel Beaters, and the other one is Viljoen. His Union Solidarity, or actually it was 7 or so employees that brought that case. That came before the Constitutional Court. In the Landman case, there was an agreed retirement age of 60. The employee worked past that, and the employer then subsequently said, this is enough, you need to go. The employee said, this is automatically unfair because it's based on age. The Viljoen case was a bit different. There was reference to the retirement fund rules and the employment conditions of SITA, the State Information Security Agency, that said once you have reached the retirement age and you continue to work past that, then you will retire at the age of 67. These employees have all worked past what was initially agreed in their contracts, but before 67. And the employer then said, no, we have the right to rely on age. You've passed your retirement age, and then terminate, but before 67. So Zondo said, sure, this is a bit harsh. In effect, you can then rely on age to bring this employment relationship to an end at any time after the person had reached retirement age. And he argued that this is actually not in line with the spirit of the Constitution. By the time he had written the WACO judgment, the Constitution had been in place just 2 years. That wasn't given proper thought to. And he said he made a mistake way back in WACO. So actually, no. You can only rely on age to bring the contract to an end on the date on which you reach retirement age. Or if the contract says it's okay, at the end of the month of that time. But the moment the employee works beyond that, that boat has sailed. You cannot now rely on age anymore. Okay, so he said it was wrong for the employer, Great South Panel Beaters, to rely on age, and Mr. Landman's retirement termination was unfair, automatically unfair, and he awarded 24 months compensation. In relation to Viljoen, the court said no, that was unfair, because actually, once they had worked past their retirement age, the employment conditions provision that said 67 is now the age, that was now what governed reliance on age, and that age had not been reached, and therefore that was unfair. Okay, so Zondo says, yes, fine, you can rely on age, but only on the date or the end of the month in which you reach that specific age, 60, 65, 63, whatever that age is. Okay. Then came Judge van Zyl, and he took a very contractual view of the matter. And he said, actually what this does, where you have this provision in your contract to terminate upon retirement age, is an election for the employer. So the employer gets an election to terminate on the basis of age, and that election must be exercised within a reasonable time. What's a reasonable time? He doesn't say. He says it depends. The facts will tell us what's a reasonable age in this, a reasonable time. In this case, the employer specifically relied on the previous judgments, which we've had since 1998. And therefore, the court said it was reasonable for the employer not to say, well, okay, this is now the end. And he said, so the failure by the employer to tell the employee that, or those 7 employees that they are retired, was in order because they relied on the previous judgment. So that was the second judgment. And then the third judgment by Rogers says, no, man. WACO was correct. That section doesn't say when you reach retirement age. It says once the employee has reached. We cannot now just, as the court, change the wording of the act. That's the wording of the act. So at any time after the employee has reached the agreed or normal retirement age, the employer can rely on age to bring that contract to an end. So the question was then, what must you do? Must you just say to the employee, yeah, didn't realize you're already 67. You look 55. But actually, you are 67, so you can pack your bags. We don't need you anymore. No, the court said there must be a reasonable heads up. So if you are going to let an employee work beyond retirement age, at least engage with the employee and say, listen, the age we agreed was 65. You're now 67. We think it is time for you to go. We are giving you 3 months. You know, we appreciate it takes time to pack up stuff and, you know, sort out things. So use the time. But then by the end of the 3 months, that is it. It is not notice. It is not notice of termination. It is the contract is going to end because of age, but you are giving the employee sufficient time to get their affairs in order. And the employee can say, listen, yo, if you can just give me 6 months instead of 3 or whatever. But the employer is then entitled to rely on age to bring that to an end. The court didn't answer the question, do you need to have like a formal hearing or a formal process? But at least, you know, from a human perspective, you need to have proper engagement with your people. So now we have these 3 judgments from the highest court. I must say, in some respects, I feel so grateful, you know, because often we disagree on the interpretation of sections, and here is the highest court disagreeing on the reasons for legislation. Yes. So that is the question is it acceptable when the employee reaches the agreed retirement age to conclude a fixed term contract for a year or 2 or to extend the retirement age? It is definitely acceptable. It gives certainty to both parties, and either of those options will work. If you agree a new retirement age, the employee will retire at that new age. The employee works beyond that, then we are in the same problem. If it is a fixed term contract, then of course the laws in relation to fixed term contracts kicking. So then there mustn't be a reasonable expectation of continued employment, which can be created by promises or repeated renewals or things like that. So one must just keep that in mind, but that is definitely possible solutions. So in this case, we have these 3 judgments, as I said, and the question is, what now? Some people have said now that the employer can choose which one it wants to rely on. No, the legal position is that the law as it stood before this uncertainty will prevail, which means the position under WACO. So an employer may rely on age to bring a contract to an end, of course, with the insight and the wisdom from this case, engage with the employee, arrange a big, you know, party with balloons and cake on the 64th birthday or whatever, and you know, everyone must know this employee is gonna go on whatever age. But yeah, it is a very interesting matter, just from the perspective of how judges can differ. I'll move along to the retrenchment case that Helen mentioned, Shushu versus Distel. So this matter has its genesis, as she mentioned, in COVID. Can you believe it is this month, 5 years ago already, how it has changed our lives? Some for the better, some for the worse. So in this case, Distel, as you know, is a manufacturer of alcoholic beverages. It has over 4,000 employees. And it said, we are severely impacted by the lockdown. You will remember back then how people started to make their own alcohol with pineapple and all kinds of things. But the sale of alcohol was prohibited. So this had a huge impact on the STEL. They wrote to the employees and said, we do not think that it is in the interest of the country or the company to retrench a lot of people. What we want to do is to implement a 10% reduction in pay. And if we are able to do that, we will save 20 million rand a month. And of course, we are also looking at other things, you know, extra lending facilities or borrowing facilities and all kinds of things to assist us in getting through this time. We think the 10% reduction will be needed for 12 months. Please agree. 60% of the workforce did. They immediately agreed, including management, everyone. 60%. Then the STEL wrote a letter to the employees who didn't agree. And it said, yo, you know, we are in this difficult process. We are now considering potential retrenchments. If we get everyone to agree, then that will be avoided. 99.9% agreed. 10 employees, actually less than 10 employees didn't. They were retrenched, and 3 of those employees took the STEL to the Labour Court. So by the time they had received the Section 1893 letter, the 20 million mark of saving had already been achieved. So the 10% reduction by these 3 employees would add another 3,500 rand to the pockets of the company. Yet they proceeded and they retrenched the employees. Eventually, the STEL said, oh, actually, you know what? Our situation had improved. The reduction was only needed for 10 months. So these employees would only have contributed 5 months or whatever. And their salaries would have actually been increased again. So the question was, were these 3 retrenchments fair? Firstly, the court looked at procedural fairness, and it said, in all the communications to the employees, the employer took the view that Section 189A applied. And because that section applied, the employee's remedy was to bring a procedurally unfair claim immediately, not link it together with this claim that is about substantive unfairness. And because they didn't do that, the employer or the court disregarded any procedural unfairness claim. So the only focus of the judgment was substance. Now, it is established that an employer may retrench employees in order to improve efficiencies and profitability. Those principles have long been established. But the court said, what is the test for a retrenchment? Let me just find it quickly. Page. It says, a decision to retrench will be substantively fair if it is a rational and reasonable response to an operational requirement, predicament faced by the employer. So that is the test that the court adopted. Is it a rational and reasonable response to an operational requirement, predicament? What is an operational requirement? It is a structural, economic, technological, or similar need. in this case, the employer said, yes, okay, we had already achieved our 20 million saving, but everyone must contribute. It's not fair that 3 people can hold out and they are not contributing. So for purposes of consistency and in order to ensure labor peace, that made it substantively fair. The court said consistency is not one of the operational reasons recognized by the courts. So what was needed was a balancing of the employer's needs through proper operational needs and the impact that this had on the employees. Incidentally, there was no evidence of a threat to labor peace if the employer hadn't gone through with these retrenchments. So the court said, what we need to do is look at the proportionality of the dismissals, because proportionality is an important component of fairness. Judge Myburgh said, you cannot use a sledgehammer to crack a nut. So you cannot use a measure that is this big to achieve a result that is this big. There must be proportionality. And because of that, it said in this inquiry, you look at the facts as they were at that stage. By that stage, it was 3,500 Rand a month that would have been added to the employer's pockets. Against that, we are balancing the impact on the employees, which was the loss of livelihood in COVID. And the court said that it cannot regard as proportionate. Also, the court took into account the 2.5 billion facility that it had secured with Remgro. So it said it was disproportionate, it was unreasonable, and therefore it was unfair. And they reinstated these employees. Now, last year we attended the Stellenbosch Labour Law Colloquium in Stellenbosch in October, and Judge van Niekerk did a paper in which he said the Labour Court and the Labour Appeal Court will look at proportionality very carefully. That is something that we will need to be alive to, and we will need to address specifically in pleadings and in considering the fairness of dismissals. But it said specifically in the case of automatically unfair dismissals, we need to look at proportionality, and it referred to the Enever Barlow World case and the LexisNexis matter. And it said, this is particularly relevant in the context of zero tolerance policies. You cannot just apply a blanket rule. You need to individualize it to the employee and check that your decision is proportionate as part of your fairness inquiry. So as I mentioned, I think it is important to take this into account whenever you are dealing with discipline or allegations of unfairness or allegations of unfair discrimination. And if the matter reaches the court, be very clear to address this issue in pleadings.
Lita, just before we let you go, with just one question on the retirement age matter that's been posted on the group, and that is, to what extent would employer be setting a precedence by extending the current retirement age, so we're keeping someone on a permanent contract versus them retiring and then entering into a fixed term contract?
Yeah, this is not a legal problem. It is more of an IR problem, because you are permitted to deal with employees' terms individually. So if someone has key skills and you require those skills, then you can let them just continue. But from an IR perspective, it makes sense to treat people consistently. So if you have a policy of entering into fixed term contracts, do that with everyone. So rather be consistent in how you manage the issue.
Thanks so much, Talita. Drew Dubé, one of our very talented younger partners who's not worried about age when he looks in the mirror, is going to take us through our next two cases. The first one, I think we can title a cautionary tale for employers. It's related to unfair discrimination and harassment. And then we will go straight into the next one, which is a defamation case. And I think shows us that we are not yet the USA when it comes to that type of litigation. Thanks, Abu.
Thanks, Helen. I think the first case I'm dealing with talks about how dangerous assumptions are. And so for Helen to assume that I'm not worried about age, that's quite a dangerous assumption, Helen. I'm very worried. Yesterday was my birthday. I was having a meltdown. But anyway, good morning, everyone. I hope everyone is good. It's good to present to some faces, and a very good morning to the people who are joining us online as well. The first case that I'm looking at is a labor court case between Melissa Padiachi, who's the plaintiff, and the Gauteng Department of Education. This case relates to a discrimination claim in terms of Section 6 of the Employment Equity Act. Now, Ms. Padiachi, the plaintiff in this matter, is a social worker who was employed by the department, and she was stationed at a school in Katlehong for children who were physically disabled. Now, around May 2022, she had a meeting with the head of the department, and the head of the department told her that they would be appointing an auxiliary social worker to assist her in coping or dealing with language barriers, which would help her to better perform her work. Now, because the school is based in Katlehong, a majority of the learners are Black African, and Ms. Padiachi is Black but of Indian descent. She was obviously very surprised by this, and she informed the head of department that she has no difficulty in performing any of her duties. A few months went by, and there was a further meeting with Ms. Padiachi and the head of the department. This time, the head of department had backup, and another colleague joined her. Again, they told her that an auxiliary social worker would be appointed to assist her with overcoming her cultural and language barriers. They also told her that she does not understand their children and their culture. As a result of this, two of the teachers in the school also stopped referring children or learners to the plaintiff, and they also told her that she does not understand their children and their culture. Now, Ms. Padiachi then took steps. She laid a grievance. She issued a number of letters of demand to the department, and the department informed her that they would investigate. A few months went by. There was no investigation. Her grievance was not dealt with. She then referred the matter to the CCMA. The CCMA, the matter was conciliated, no resolution. The matter then went to the Labor Court. In the Labor Court, the department decided that they would not oppose the matter, so there was no statement of response filed, and therefore Ms. Padiachi's evidence went uncontested. In her evidence, she spoke about how the conduct of the department's officials and the teachers had impacted her, how it had caused her psychological harm, physical harm, emotional harm, and ultimately she claimed that she was being harassed and discriminated against on the basis of race, language, culture, and ethnicity. Because the evidence was uncontested, the court accepted the evidence, and found that the employer in actually, or rather the department, in not doing anything to address the grievance that was laid by Ms. Padiachi, that it had actually not performed its duties as required and was therefore liable for any discrimination that would have been caused against Ms. Padiachi, and had itself actually discriminated against Ms. Padiachi. The court then had to determine what would be just and equitable under the circumstances, and decided to award Ms. Padiachi 50,000 Rand for the damages that she was claiming. The department was also ordered to investigate the allegations and also deal with the grievance that Ms. Padiachi had laid. Personally, I think 50,000 Rand is nothing. I'm not too sure why that is the amount the court felt was just and equitable, but I think the takeaway really from this case is, if there are harassment claims, then as the employer, you need to investigate those claims, those grievances, deal with those grievances, and more importantly, don't make assumptions based on people's ethnicity, race, etc., as to what languages they're able to communicate in, as was the case by the department. Move on to the next case. The next case was a High Court application. That is the matter of Rogers Ndobo versus Gibela Rail Consortium. So in this case, Mr. Ndobe actually sued his previous employer for defamation. What he claimed was that an investigation report that was used in a disciplinary hearing was actually defamatory, and that it had been published to various employees, and it resulted in his reputation being harmed. He was seeking 5 million Rand in damages against his previous employer. The report was titled Rogers Management of Design Group. As I've indicated, it was used for the purpose of a disciplinary hearing. Now, in the disciplinary hearing, he was found guilty of the allegations against him. However, on appeal, the appeal board or the appeal panel found that the sanction of dismissal was actually too harsh. A number of months went by. He then referred or initiated proceedings in the High Court for defamation, where he claimed that the report contained inaccurate statements, that it was unlawful for the report to be published, and that what was contained in the report was actually defamatory against him. So the court then had to consider, there's two elements to defamation. So the first element being whether a defamatory statement had been made, and two, whether there was publication. Now, in considering the evidence that was before the High Court, in looking at the first question, the court found that whether or not a defamatory statement has been made is a question of law which a court must determine. The court also looked at the report and found that the title of the report placed emphasis on what Rogers had actually done, that the title of the report created the impression that Rogers was responsible for managing a project that had actually resulted in a loss of about 6.8 million Rand. What the report, on a plain reading of the report, the court found that a reasonable person reading the report would conclude that what had happened was there was a project, Mr. Rogers was responsible for the project, and because of Mr. Rogers's bad management of the project had failed and resulted in a loss of 6.8 million Rand. The inaccuracy in this was that Mr. Rogers was not managing the project. There were other employees who were responsible for managing the project, and he was just working on the project. So the court found that what was contained in, or the inaccuracies in the report, may have had the result of Mr. Rogers's esteem being nullified or not nullified, sorry, it would have harmed Mr. Rogers' esteem, reputation, and therefore the court found that what the report contained may amount to defamation. The second test was then whether or not there was publication. Now, the report was used in a disciplinary hearing, so obviously it would have been distributed to people involved in the disciplinary hearing. There was a dispute as to whether the report was distributed to other employees who were not part of the hearing, but the court ultimately found that the report was distributed to the chairperson of the hearing, an HR representative, to Mr. Ndobe, the plaintiff, and one copy was then retained by the employer's representative. The court found that this does not amount to publication. And further, because the report was used in a process that is legally sanctioned, this amounted to a privileged event. And if the report is being used in a privileged event, a legally sanctioned event, there cannot be publication. The report was essential for the purpose of the hearing, and it was used solely for the purpose of the hearing. Therefore, the plaintiff failed to establish publication, and the claim for defamation was then dismissed. I think what's important from this case is if you're going to use an investigation report in a disciplinary hearing, you need to make sure that it is very accurate. And you also need to make sure that you confidentiality, you maintain confidentiality. So make sure that the report is only published to individuals who are necessary, individuals who are involved in the hearing itself. The court also ensure that the report that you use is not used for a malicious intent and that it's solely used for the purpose of the hearing. I personally did not think there could be a scenario where an employee says the report that you used in the hearing amounts to defamation against me, but we live and we learn. Thankfully for this employer, it was for good reason. I am not a fan of using investigation reports in disciplinary hearings. I prefer to just call people to testify to what the investigation report reveals. Those are my two cases. Don't know if there's any questions, but I think they were quite clear and straightforward. Thank you.
Thanks so much, Bruce. I think some interesting learnings from both of those. So just to let you know, there's been some questions posted in the chat, which we're responding to directly. Nadine Mather is going to take us through our next two cases. Nadine is familiar to, I think, most people here online, not only as an employment expert, also as a data privacy expert. The first case that Nadine will take us through relates to reinstatement, and I think emphasizes that employment rights and obligations are reciprocal. So it's not just on the employer, it's also on the employee. And then the second case relates to what I think is often the trickiest type of dismissal, which is an incapacity for ill health. And I think this case, there's some good learnings. I know this is a real pain point sometimes for our for clients and employers. And I think this case highlights why that is the case. Thanks so much, Nadine.
Morning, everyone. It is great to see some familiar faces in the room, and welcome to our guests online. When an employee is reinstated, I think one of the pressing questions for employers is how long do you have to keep the employee's position open? We had a client that came to us at the beginning of the year who had dismissed an employee in February 2022. And in January this year, the employee wrote to the company and said, "Hello, I am ready to be reinstated, and I will be reinstated with effect from February this year," 3 years after the reinstatement order. Was the company obliged to reinstate the employee? How long does an employer have to keep the door open for an employee? And this was the exact question that came up in the case of South African Municipal Workers Union, OBO Koopman versus City of Cape Town and others. Now, in this matter, Mr. Koopman was dismissed by the City of Cape Town following a disciplinary hearing in February 2014. Now, aggrieved by this decision, he went to the applicable bargaining council, and the bargaining council found in his favor and awarded reinstatement, retrospective reinstatement, to 25th of February 2014. Now, Mr. Koopman decided in August 2022, approximately 8 years later, to get the arbitration award certified. And in 2023, he launched contempt of court application against the city on the basis that they had failed to comply with the arbitration award. Now, before the Labour Court, the city raised the defense of prescription. The city said that an arbitration award is a debt in terms of the Prescription Act, and it prescribes after 3 years. So on this basis, there can be no contempt application. The Labour Court agreed with the city and said, you're right, it does prescribe after 3 years. And in fact, it had prescribed in 2017, which was 5 years before Mr. Koopman sought to certify the award. It also noted that Mr. Koopman had not tendered his services to the city, and the city had not refused to take him back into employment. So on this basis, the Labour Court dismissed the contempt application relating to the fact that the arbitration award had prescribed. Mr. Koopman was upset. He then decided to take the Labour Court judgment on appeal to the Labour Appeal Court. And he argued that no, an arbitration award is not a debt for purposes of the prescription. Once certified, it only prescribes after 30 years, the same as court judgments. The city, on the other hand, argued the Labour Court was correct in its finding on prescription. And even if Mr. Koopman's argument was correct, it had prescribed before certification, and the certification didn't change the legal status of the award. But importantly, to date, Mr. Koopman had not tendered his services following the reinstatement order. So the Labour Appeal Court said, well, if it is true that Mr. Koopman did not at any stage seek to tender his services, that's the end of the matter. It will dismiss the appeal. We don't even have to go into the question of prescription. That question becomes moot. So the court decided to turn its focus on the issue of whether Mr. Koopman had tendered his services. Now, in this regard, the Labour Appeal Court said one of the fundamental principles of your employer and employee relationship is that the employee must tender their services and the employer must, in return, remunerate them for tendering their services. So it creates reciprocal obligations. A reinstatement order does not itself reinstate an employee. It requires obligations on the employee to tender the services and the employer to accept the tender. The Labour Appeal Court went further and said once an employee is dismissed, that contract of employment terminates. And that contract can only revive if the employee then tenders their services. So an employee has an election. If they would like to be reinstated, they are required to then tender their services within the time period prescribed in the reinstatement order, or on good cause shown in a reasonable time thereafter. If they do not do that and they don't exercise that election, their right of reinstatement lapses. And now, against this background, the court reiterated that the right to fair labor practices also extends to employers. It's not fair or reasonable to require an employee to keep an employee's position open indefinitely following a reinstatement order, for the employee to decide, well, today is the day, 8 years later, that I am going to return to work. Now, in the present matter, there was no evidence that Mr. Koopman had tendered services. And on this basis, his appeal had to have failed. In turning to relief, and actually in a postscript in the judgment, the Labour Appeal Court interestingly decided to refer this judgment to the Minister of Employment and Labour to see if there are any legislative amendments that could be made to try and at least prevent similar situations like this going forward. So a proposal by the court, for example, was that an employer may need to initiate communication to an employee after the appeal or the review proceedings have lapsed, if any, indicating by when they expect the employee to tender their services. This, in the court's view, may create more clarity for both employers and employees, but the obligation still remains on the employee to tender the services. So just in terms of some key takeaways, as mentioned by Helen, there is a reciprocal obligation on an employee and employer in a reinstatement order. The order is not sufficient in and of itself, and an employer does not indefinitely have to keep an employee's seat warm. An employer must tender services within a reasonable time frame from the award. So if the award stipulates a date, it's by then, or within a reasonable time frame thereafter on good cause. What is a reasonable time frame? Well, that will always depend on the circumstances of the case. Probably a few months. I would argue certainly not 3 years in our client's case, and definitely not 8 years in the present case. And if you ever find yourself in a situation similar to our client or the city of Cape Town, you are not obliged to then reinstate the employee. So moving on to the second case I'm going to discuss today, and as Helen mentioned, it concerns mental health in the workplace. And there was that poll that was put up earlier. One of the issues was mental health and whether this keeps employers up at night. And it was quite interesting that it got, I think, was the third sort of highest on the poll. And in the current workplace and the times we find ourselves in, I do believe that mental health challenges are gaining a sort of attraction, specifically in that it's pivotal to employee well-being. And it certainly can be difficult for employers to manage cases, but it is more challenging to navigate mental health issues where they may arise as a result of workplace-related incidents. Now, as I'm sure you are all aware, there's a code of good practice on dismissal, and when it comes to incapacity cases dealing with ill health, the code requires an employer to consider whether an employee is capable of performing their duties. If the employee is not capable, to what extent is the employee able to perform their duties? In what manner can the employee's work circumstances be adapted to accommodate the employee? And if not, can their duties be adapted? Or is there any alternative suitable work that can be given to the employee? Importantly, and in addition to this, the code expressly places a more onerous obligation on employers to reasonably accommodate an employee where their incapacity or their injury has been as a result of work circumstances, or the incapacity is related to workplace incidents. Now, this was the very matter that the Labour Court was considering in Le Franschhoek Hotel versus CCMA and others. And it really delved into the questions of what is reasonable accommodation and how far does an employer's duty go to accommodate an employee in the workplace. So in this matter, the employee, Mr. Feroz, was employed by Le Franschhoek Hotels as the executive chef. Now, he managed over 3 restaurants, he managed the staff services, the rental hotel rooms, and part of his duties was managing the kitchen and training employees on health and safety requirements. Now, in January 2019, whilst he was off duty, the employee received a call from his staff saying the kitchen was on fire, right? A chip maker had caught a light and the house was on fire. So the employee decided, he immediately got up, rushed to the scene to try and help. And as he got to the scene, the fire was out of control. But the employee stood up, he used his sort of firefighting training, and he took control to contain the fire. And when emergency services arrived on the scene, they actually praised the employee for the job that he'd done. They said, but for the employee's action, the whole building would have burned down. So the employee carried on working. January and February and March were an incredibly busy time for the hotel, and he put his head down and carried on. But in March, started explaining that he was suffering from some panic attacks, anxiety, and had difficulty sleeping. And this resulted in him taking a few days off and being absent for a few days, and then intermittently being absent over the following months. And when he raised this issue with his line manager, his manager referred him to ICAS, and the employee then went to get an evaluation by an independent medical practitioner. And he was diagnosed with a mental depression episode and anxiety and some traces of post-traumatic stress disorder from instances relating to the fire. And this medical practitioner says he needs time off. He needs to be placed on light duty or give him additional sick leave or at least a few months for him to get adequate treatment. So the employer said, well, okay, that's nice, but we want you to go get another assessment and we'll pay, we'll send you to another medical practitioner. And off he went. And this medical practitioner similarly said he does need help, but I would actually recommend a 21-day inpatient clinic program, treatment program. And I believe that if he goes through this program, he will fully recover and be able to perform his job exactly how he's been able to do so before. I would also recommend that the employer pay for this inpatient treatment and they can claim it back from the workers' compensation. The employer did not pay for the treatment. The employer decided, you know what, we will give you 2 months. You can go and sort out your mental ill health in your own personal capacity over the next 2 months. In the meantime, the employer found a temporary replacement, and they had indicated that his job of executive chef, you just cannot change. You can't alter the duties, you can't reasonably accommodate. So we've got a temporary replacement and go and get the necessary help. So it took the employee longer to get the necessary help, and he eventually went into inpatient treatment program in a clinic in October until mid-November. And he indicated that he was ready to return to work. And the organizational therapist from the clinic issued upon his discharge some recommendations to say, the employee can return to work. I would recommend that the employee take steps to support the employee in this regard and that they consider how best to reintegrate him in the workplace. And whilst he can perform his duties, the employer should still consider whether there's any way they can sort of change the duties to make it less stressful and demanding. The employee returns to work in December, and the employer initiates an incapacity hearing and dismisses the employee. Upset by this, the employer obviously refers an unfair dismissal dispute to the CCMA. Now, at the CCMA, the commissioner found, specifically looking at the Code of Good Practice, that there is this obligation on employers that is more onerous when employees suffer from incapacity as a result of workplace incidents. She found that the employee's mental ill health was directly as a result of the fire, and there was no evidence that the employer had supported the employee, that the employer had reasonably accommodated or sought to reasonably accommodate the employee. The commissioner also noted that the incapacity was not permanent, that the employee had sought treatment and the employee was ready to resume his duties. And in fact, once the employee returned to work, in fact, once the employer decided not to pay, if the employer had provided the necessary support and arranged, whether they paid or not, but arranged for the medical treatment, it didn't put this all on the employee, he wouldn't have been absent for so long. He would have been absent for less days. He would have been able to resume his duties a lot, closer than December. So in summary, the commissioner concluded the employee was incapacitated as a result of a fire that was at the workplace, and a fire in which the employee put his own safety and life at risk for the employer's purposes to save the building. And the employer took no steps to support the employee, to bring them back to work and reintegrate them in the workplace. On this basis, the dismissal was found to be substantively unfair, and the employee was awarded 6 months' salary. Does the employer not take this award on review? And the review was actually not opposed. The employee did not have representation, so the employer decided to try their luck and went to the Labour Court to review this decision. And as the Labour Court normally does, they just restated the review test and made it clear that the obligation is on the litigant to show basis on why the commissioner's award is unreasonable. So the court turned to the evidence. And they said it's common cause that the employee's ill health was as a result of the fire. And worse off for the employer, the medical recommendations, the medical diagnosis, none of it was challenged or disputed. This was all common cause. Again, it was common cause that the employer did not provide any support. They did not take steps to reasonably accommodate the employer. But the Labour Court actually took one step further, and they said the problem you have is there was no requirement to reasonably accommodate the employee, because in December, when he returned to work and you initiated an incapacity inquiry, he was well. He was ready to return to his duties. He showed up. So in essence, it was a dismissal because the employee came, tendered his services, went back to the first case, wanted to resume his position, and the employer said no, even in circumstances where that position was still vacant. So the Labour Court in this matter held, we cannot interfere with the Commissioner's award. It was right, it was reasonable, and the employer's conduct, of course, constituted a dismissal in these circumstances. So I think just in terms of some key takeaways, completely appreciate that ill health is challenging for employers to manage. And there is this requirement to provide support, to try and reasonably accommodate the employee, and to work with the employee in investigating the matter to see what would work for the employer, obviously subject to its operational requirements. Mental health is just as serious as physical workplace industry. So we've got to treat it the same. It is sometimes often more difficult because of your difficult medical reports, the different types of treatments one may need, but it is equally as serious. And of course, if an employer does not take steps to try and support the employee or follow the code of good practice, you will find yourself in a position where the dismissal will be regarded as unfair. Thanks very much, everyone. I don't know if there are questions.
There are two questions just on the group. So the
Right.
first one is with regards to mental illness. We have an employee who claims he continues to be late at work due to depression and not being able to sleep. Would this be a situation we deal with under incapacity?
Yes, I would say that would be a situation you deal with under incapacity. He's, late coming could constitute misconduct, but here the employee specifically has explained that he believes his late coming is as a result of depression. He can't wake up in the morning, and that's quite a common side effect there. So the position would be, it would be incapacity. You would have to start an investigation, consult with the employee, find out how, if he can perform his duties, how you can resolve this late coming, can you reasonably accommodate him? And of course, you can request medical assessments. You can ask him to undergo that to get more information to decide. It is a difficult job. I mean, we've had, cases where employees come and they say, I can't attend meetings. I'm not attending the workplace in person. And they list all these demands. And then they say, it's because I have epilepsy. And the employer sits there and they're like, but how thank you for disclosing this, but how does the condition relate to all these requirements you ask? So the requirement to say, I can't drive to the workplace. Okay, that makes sense with epilepsy, requirements can be made, but the requirement to say, I only need to work from home, don't quite know. So again, it's an investigation. We need to understand the mental health condition and how it impacts on the duties. Once that's been done, how you can reasonably accommodate, if possible, the employee or alter their duties to assist in that circumstance.
Thanks, Nadine. And then the second question is putting us on the spot or keeping us on our toes. It's how is the reasoning on the Koopman case, which is the reinstatement case, different from the Constitutional Court reasoning in a case dated from 2016? I mean, my recollection of that one was that it actually related to a reinstatement or that had been made an order of court, and it dealt with prescription. So I think it was a different case. Looking at it through a different legal lens, but yeah.
Yeah, so the court, the Labour Court did go into various authority, and one of the authorities I mentioned was the Constitutional Court judgment, but there was contradictory authority on the issue of prescription, specifically in respect of arbitration awards. And the Labour Court went into that, and the Labour Court said, well, they aligned with the Con Court and said, they believe it is a debt where there are judgments that don't agree with that approach. The Labour Appeal Court did not go into that issue on the very basis that they felt there was no need to get to the issue of prescription or deciding what an arbitration award, whether it was a debt or a judgment, because you have to start with the tendering of services. And on that basis, that issue was not, the prescription issue was not considered by the Labour Appeal Court. But yeah. Thanks very much.
Thanks, Nadine. Guys, thanks for hanging there. We are almost there. The three cases taking us home are all related to restraints of trade. Ros Davies is going to take us to the first two. And thanks very much to Ros for actually putting the whole employment law update together. The first case, I mean, I don't think that the applicants would have been happy in any of these cases. I think they would have all gone home disappointed. The first case that Ros will take us through looks at the partial enforcement of an award. And the second one was basically rewarded a very creative defense by the ex-employee, which I think the lawyers would have stuck in the papers and been very surprised when they were successful with it. So thanks, Ros.
Thanks, Health. Morning, everyone. So firstly, I think Helen's giving me a bit too much credit on putting this together, and I have to admit that Chloe did most of the work. So really my thanks are to Chloe. She took a lot off my desk. So I'm going to start with Baring Man Group versus Herholt and Baring Warehouse. Now, I think I'm calling it Baring, but it's Baring. So this case involved a restraint of trade. What happens is that BMG and BW are competitors. They operate in exactly the same industry, and they compete against one another in respect specifically of two products. So it's not a competitor across the board, but there are these two products where they compete directly. Herholt was originally employed by BMG. She worked with BMG for a number of years. At the time, she did not have a restraint of trade. She then went and worked for BW, so Baring Warehouse. And she was there for a couple of years, and BMG started losing revenue, and it needed a strong salesperson. And Herholt was, in the market, a very strong salesperson. So they then headhunted her, and she came back to work for BMG. When she returned, because she was seen to be so important by BMG, she was given double the salary of all other sales reps at BMG. She was known in the market to be very successful. And I think during the period of her employment, her second employment with BMG, she was doing about 139% of sales. So she really was the salesperson. When she was offered re-employment by BMG, she was required to sign a restraint of trade agreement. She signed the restraint of trade agreement, and the restraint of trade agreement, you're still in a restraint, but for today's purposes, the key issues were she couldn't take up employment with a competitor, and she couldn't solicit customers. And then thirdly, the restraint was for a period of 24 months. Now, in South Africa, usually we advise clients 6 to 12 months is a reasonable period for a restraint. Anything longer than that, you need as the employer to specifically justify why a longer restraint is necessary. When she returned to BMG, there was a huge increase in sales. BMG was doing very well, but I think there was still some financial instability. In September 2024, Herholt gave notice of her resignation, which would be effective from 31 October 2024. That then would trigger her restraint period, which would run for a period of 24 months from the 31st of October, so let's say the 1st of November. It's unclear whether she disclosed to BMG that she was going back to BW, but that the court didn't find relevant. BMG knew she was going back to BW and said, we are going to enforce the restraint, so please don't breach your restraint. She indicated that she didn't believe she was bound by the restraint, she didn't believe it was reasonable, and she was taking up employment with BW. BMG then sought to interdict her and from taking up employment with a competitor, including BW, and to enforce the restraint of trade. Now, I'm just going to talk briefly about the legal principles in restraints of trade. So the standard position in South Africa is a restraint of trade is considered on the face of it to be enforceable. In order to get out of a restraint of trade, the employee needs to prove that the restraint of trade is unreasonable. That said, it is always for the company to show why they put that restraint in place. So the first issue for a restraint of trade to be found to be enforceable is that it must be reasonable. So the questions you have to ask is there a proprietary interest worthy of protection? If there is a proprietary interest worthy of protection, does the employee create a risk? If that is also answered in the positive, then the next question is the restraint reasonable as to duration, so the length of time, and to geographical location? So you need, as the employer, to show why the period is necessary and why the geographical location is necessary. In considering whether or not to enforce a restraint of trade, the court must make a value judgment. And there are two policy considerations that the court has to weigh up. The first is that it's accepted in our law that it is in the public interest that parties to a contract get held to their contractual undertakings. So that's your sanctity of contract principle. The other principle is that it's in the public interest that all people are able to be productive in society and that they are permitted to engage in their trade, occupation, or profession of choice. So you've got these two essentially potentially conflicting interests. And what the court has to do is balance those out and see whether it is in the public interest to prevent an employee from taking up employment. And the question then has to turn on, if that employee does so, does it create a risk to the old employer? Then, in assessing enforceability, the court will look at the nature of the business and the market, the employee's employment history, whether or not the employee has access to confidential information, customer relations, among others, and the bargaining positions of the parties. So bargaining position is considered when establishing if there is an enforceable restraint. Now, it was common cause in this case that BMG and BW were competitors. Handheld, however, said, but the customers are the same. In the industry, there are only a certain number of role players, and it's common in the industry for customers to pick up the phone to each one of the suppliers and ask what deals they would get. So she said, this then makes it irrelevant if I know the prices and if I know discounts, because customers phone and ask themselves. There was also a dispute about whether or not she had knowledge of confidential information contained in their CMR, their CRM program, which is their customer relations program. And the court said, look, they accepted that she actually didn't really use the program. She was out and about. She was visiting customers. She was speaking to them. She was, on the road. So the court didn't really consider that. But the court was concerned about her direct dealings with customers and the fact that she had really good relationships with these customers. And the court said that these relationships, or her relationships and her knowledge of the customers, could be used to benefit BW and thereby to harm BMG. So the court accepted that even though that they had essentially similar customer lists, that her knowledge and her recent dealings with customers could be used to advantage BW. In then weighing up the competing interests, the court said that it believed that it was in the interests of both parties that there be a partial enforcement of the restraint. Now, previously, the court has previously done partial enforcements, but the general position of the court has been, don't get us to rewrite your restraint. You come with a restraint, and I'll either enforce it or I won't. Don't come and say, oh, well, sever it here or change this. But in this specific case, the court said, you know what? It's in the interest, it's a public interest to do a partial restraint to, protect BMG, but also to allow BW to take up gainful employment. And in this specific case, the court limited the interdict to preventing Handheld from taking up employment with BW until the 1st of January 2025, so only for a period of 2 months, which, yes, I see from Talita's face that this is, it's difficult to comprehend. And then to prevent her from approaching customers in a specific confidential list that had been put before the court until the 31st of March, 2025. So it was a significantly reduced restraint. So guys, lessons. When sitting there and thinking, what do we need from a restraint of trade perspective, and advising your lawyers on it, think about what is the proprietary interest you are seeking to protect. Think about the specific employee or category of employees and what risk they pose if there isn't a restraint. And then look at what do you need to do? What is reasonable and necessary to protect that proprietary interest? So because in this case, there were common customers shopped around, the court was looking at this going, well, 24 months, that's not reasonable. What we're seeking to protect here is the specific relationship that Handheld had at the time and in recent history with customers. And I think the court, although they didn't say it, I think the court's thinking was, but that is short-lived. That information will change quite soon. It's not going to be information that's going to be relevant in 6 or 10 months' time. And it was for that reason that they gave this very truncated restraint of trade. Any questions on that from anyone in the room? Okay, then I'm going to go on to the next case. And this for me is a challenging case. So we've gone through the legal principles, no questions there. We know what those are now. In Altron Nexus versus Fowler and MST Critical Communications, Mr. Fowler was employed by Altron Nexus. Originally, he was employed as a technician, and he was later given a position as a sales representative. He had signed a restraint of trade. The restraint of trade was for 12 months in the Republic of South Africa, and he was not to take up employment with a competitor, not to solicit the custom of any customers of Altron Nexus, etc. So a pretty standard restraint. So the first question is there a proprietary interest worthy of protection? Now, on the face of it, he's a sales representative. He has access to customers. He has relationship with customers, knows customer lists, new pricing, new confidential information relating to marketing, etc. So all of that information, as a sales representative, he likely had access to. So there probably was a proprietary interest worthy of protection. And then it follows that because he has this information, he poses a risk to Altron Nexus if he were to go to a competitor. So we tick those two boxes, or I think we tick those two boxes. Fowler then resigns from Altron Nexus and he takes up employment with MST. After his resignation, Altron Nexus reminded him of the restraint of trade and said to him, we are going to enforce the restraint of trade. You cannot take up employment with MST for a period of 12 months, with MST and any other competitor, and you can't approach our customers for this period either. He said, no, I don't believe the restraint is enforceable. What he said is that, firstly, when he signed the restraint of trade, there was unequal bargaining. He said at his previous employer, he had been retrenched, and therefore he was desperate to take up this job, and so he had to sign the restraint of trade. He also sort of then claimed that that was some form of duress. The court said, no, that's not how it works. Firstly, you had already been employed by Altron as a technician. You didn't need to take up the position of a sales representative. You chose to do so. You had equal bargaining power in that. You weren't that desperate. In relation to duress, the court didn't even consider it. They just said there's no evidence of duress, and they dismissed that out of hand. He then said that, he couldn't really do harm to the business. The court said, no, you are a sales representative. We accept that you have customer relationships. We accept you have knowledge of pricing. You have knowledge of marketing plans. You have knowledge of discounts offered. We accept that there is information that you have and that could be used to the detriment of Altron. That, however, did not end the case, because the other issue that Fowler had raised was that there had previously been an inconsistent enforcement of restraints of trade. Now, prior to this, inconsistency in the enforcement of restraints of trade has never been an issue. I haven't seen any cases on it. I think that the judge actually in the judgment says she hasn't seen any cases, or he hasn't seen any cases on it. So it's never been an issue, and it's certainly never been a factor that I have considered. What the court said here, though, was that if you are saying you have a proprietary interest worthy of protection, it is unreasonable to enforce the restraint against some people and not against others. I suppose if you've got a legitimate reason and you can say, well, I'm not enforcing it against Talita because Talita actually doesn't have the confidential information I'm seeking to protect. So if you've got a legitimate reason, that might be different. In this case, although Altron said, no, we deny that we have been inconsistent, we deny there's been any unfairness, Altron didn't put any evidence before the court on previous enforcement of the restraints of trade and reasons for not enforcing the restraint of trade in respect of some people. So the court said on that basis, it was satisfied that there wasn't a reasonable basis for the inconsistent enforcement. And the court then looked at the question of, is it reasonable to enforce the restraint against some employees and not others? And they said, unless there's a valid reason for doing so, it is unreasonable and it renders the restraint unreasonable. The other thing that the court was concerned by was that Fowler was only informed that they would enforce his restraint after he had resigned. And they said he was reasonable in his belief that the restraint would not be enforced. So guys, the lessons from this case, sorry, well, in that regard, let me just go back. The finding was that the restraint of trade was unreasonable. The application was dismissed and the court declined to enforce the restraint, even though it accepted that there was a proprietary interest worthy of protection, that Fowler posed a risk to Altron Nexus, and that the restraint in all other respects was reasonable. So the lessons: if you have restraints of trade in the business, be consistent in applying them. Again, don't have a blanket restraint of trade for all employees. Consider why you need a restraint in respect of categories of employees. What is the harm? If there is a reason that you decide not to enforce a restraint, you need to be sure of what that is. And just saying, oh, we don't want to spend the money on enforcement is not going to help you in a case like this. So you need to be clear. If you have historically, for whatever reason, not enforced restraints of trade, what you need to do is then say to your employees, I'm drawing a line in the sand. Going forward, notwithstanding that we may not have enforced restraints historically, going forward, we will do so. And the court in Altron Nexus case said, implied rather, had the employee been told before he resigned that his restraint would be enforced if he left to go to a competitor, the outcome may have been different. Thanks very much, everyone. Any questions on that case? Okay, thank you.
Thanks so much, Roz. Sorry, we're running slightly over, guys, but just one last interesting case on restraints. Lenia Dams-Jansen is going to take us to us, and Lenia is an employment expert and also a rewards advisory expert. So it's good to have her taking us through this case. And Lenia, I think this one's very interesting because it looks at the reason for termination on restraints. Yeah.
Got this one. Good morning, everyone. Thanks for coming through. Just bear with me. I've got 8 minutes to talk to you about this case. It will be of use to you. And good morning to everyone online. It's good to be seen by you, even if we aren't seeing you. So this case involves two parties. The one is called Back Sports, who was the employer in the situation, and then an employee called Ofense Mutlanke and another. The brief background to this is that Back Sports is a company that provides broadcasting, advertising, social media, and production services. And the first respondent, Mr. Mutlanke, was employed by Back Sports as a senior stream leader, but for a very short period of time. So he was employed at the beginning of January 2024, and then he was summarily dismissed towards the end of, well, the middle of October that same year. Unfortunately, the court doesn't go into why he was summarily dismissed, but it does say that there were 7 charges of misconduct leveled against him. The second respondent, as is usually the case, was a company of which Mr. Mutlanke was the sole director, called Optics Media. So in January of this year, the company filed an application to enforce a restraint against Motlhanke to interdict and restrain him from soliciting its clients and employees, from threatening and harassing its directors and employees, and from damaging or sabotaging its assets, and specifically an outdoor broadcasting truck. So the restraint of trade in Motlhanke's contract of employment stipulated that he would not compete with BAK Sports for a period of 12 months. And the geographical scope of the restraint was all of the provinces in South Africa and any other country or territory where the group operated. The allegations of breach that BAK Sports leveled against Motlhanke in the court were several. So firstly, they alleged that he had attempted to solicit another employee to leave its employ. Secondly, that he had approached a client of its to seek employment and solicit direct employment by that client. Thirdly, that his other company, which was Optic Metrics, of which he was the sole director, had provided streaming services to another client of BAK Sports at an award ceremony event. And then finally, that he intended to sabotage BAK's, I'm not going to put it in quotes because maybe he did, but he intended to sabotage BAK Sports assets and specifically an outdoor, like I said, the outdoor broadcasting truck that it had. And he had made certain threats to take down senior leaders within the organization as well. So as it would be, Motlhanke denied the allegations of solicitation. He said that this employee at the company was just a friend and he just wanted to set up a photo shoot because he didn't have his own camera at the time. But interestingly enough, he did concede to approaching the client for employment. And he did also concede to being at this event and providing streaming services for one of the clients as well. So on the face of it, if we think about the principles that Roz has enunciated, there is a restraint agreement in place, and for all intents and purposes, we've established some sort of breach of the restraint agreement. But what Motlhanke ultimately alleged, and this is important for what I'm discussing, is he said he was not using any trade secrets to gain an unfair advantage. And he also, the role that he had occupied didn't give him any access to customers or clients of BAK Sports. So in conducting its analysis, the court considered various factors. It started out with the principles that Roz has already said. So basically, we've got a de facto breach of restraint, which is prima facie enforceable. It then falls to the employee to say that the restraint is unreasonable, which Mr. Motlhanke did. So the test for reasonableness requires you to establish that there is a proprietary interest, the interest is being prejudiced, and importantly, whether the interest outweighs the employee's entitlement to engage economically in activities. What the court emphasized is that you cannot use restraint of trade agreements for the sole purpose of wholesale excluding any competition from your ex-employees. It's intended to safeguard proprietary interests in the form of confidential information or trade connections, which can be your suppliers, which can be your customers. So ultimately, in order to enforce a restraint agreement, you must be able to show that the employee had access to confidential information, trade connections, and importantly, that they used it to gain an unfair competitive advantage against you. So the court considered the issue of proprietary interests, and it found that BAK Sports claimed that Motlhanke had access to customer lists and that he was introduced to major customers of its business just wasn't established on the papers, right? So they made all of these broad allocations, but they provided no detailed information of what was his job description, what were his day-to-day activities, what was the type of work that he did that led you to conclude that, he had customer connections, trade connections. All that they did is they basically relied on a few WhatsApp groups that had been established by the company for operational purposes, for, when you're on site and you're broadcasting and providing the services for everyone to engage and liaise with each other. They said because there was one group which Motlhanke was on with clients, that was the basis for his customer connections. The court also noted that BAK Sports didn't have exclusive relationships with these customers as well, and that Motlhanke's position didn't entitle him or allow him to interact directly with customers. The court was really frustrated with the evidence that was put forward, and they said, well, you haven't given us anything, so all we can really do is speculate in these circumstances on the allegations that are being made. So on this basis, they found that because of the lack of evidence, BAC Sports had not established a proprietary interest. They didn't stop there, though. They also did go on to consider the reasonableness of the restraint. So what they noted here is that Motlanthe had been employed for a period of less than 12 months, but BAC Sports was seeking to hold him to a restraint period of 12 months, which already seems disproportional. But interestingly, what they also said is you have to give consideration to the circumstances surrounding the termination of his employment. And when the court went on to consider these circumstances, what it concluded expressly is that by dismissing Motlanthe, it had waived its rights to enforce the restraint of trade agreement against him. And it used that strong language that it had waived its rights, and held that it would be an entirely unjustified limitation of Motlanthe's rights if the employer was to enforce the restraint against someone who had been dismissed. And I'll touch on this at the end because none of us agree with it from the facial expressions that I'm seeing. And then just quickly on basically what the court found is that BAC Sports had acted entirely in bad faith in bringing this application. So I think that the ultimate focus was that the duration of the restraint wasn't fair, proprietary interest wasn't established, and it was brought in bad faith just to delay and cease any type of competition. On the criminal allegations, they said that they can't make a finding of this because there wasn't any ongoing employment relationship between the parties. And they also said, you know, whether or not he's making threats doesn't strictly inform the application of the scope of the restraint. So they didn't deal with that. But because they were displeased with BAC Sports, they did order costs against BAC Sports in this instance as well. So what are the key takeaways here? As Roz has already said, ensure that the restraint agreement clearly defines the proprietary interests that you're seeking to protect. So is it customer connections? Is it confidential information? What is the nature of the business and what is the nature of the services that the employee is rendering? Also, if a dispute arises, submit proper evidence. You can't submit hearsay evidence. WhatsApp messages may be of some evidence, but they need to legitimately establish trade connections or client confidential information. Again, always bear this issue of reasonableness in mind. So assess the duration of the restraint, the scope of the restraint, the employee's role, whether there should be a restraint in the first place. And you can, to an extent, look at the circumstances of the departure as well. Again, also avoid overreach. You can't preclude employees from competing with you just for the sake of competing. And then finally, like I said, this case seems to propose in strong terms that where an employee is dismissed, the employer will be deemed to have waived its rights to enforce a restraint. So we can all think of a lot of scenarios where, you know, an employee who has a restraint in the 6 months leading up to the resignation establishes a side hustle, makes contact with a competitor, where client lists are disclosed, where confidential information is leaked. And in those instances, there's a very legitimate basis for an employer, if they become aware of that information, to discipline and dismiss. So we don't think that the court was right on this. Consideration can be given to the circumstances of the termination. I think in this instance, like I said, because the duration of the employment was so short, balanced against the scope of the restraint and the fact that there wasn't a proprietary interest, that ought to have been the focus more. But the circumstances surrounding a dismissal is only one amongst a host of factors that an employer, a court should be considering when determining whether or not a restraint is reasonable. I guess the only issue with this is that it is case law and opportunistic parties might seek to rely on this. So any questions or concerns? Probably some concerns, but any questions? All good. Okay. Thank you so much.
Thanks, Lenia. Yeah, that seems a classic case of rewarding bad behavior. Well, the one thing we'll just add is that if you retrench someone, that there's a lot of discussion about you can't enforce a restraint. There's not really case law on that, but that makes a lot more sense. If you don't need the person saying that they can go to a competitor, then someone you dismiss for misconduct and then kind of hops the fence. But But we're going to end there. Sorry, everyone. We've run over slightly, but we are thrilled to have you both online and in person. They say feedback is a gift and we welcome it, good and bad. If you do have an opportunity just to scan, as we said, this hybrid has been a trial for us. So we would love to learn from your experience of it, both the people online and in person. But otherwise, we are going to wrap up there. Chloe will be sending out the summaries early next week of the cases. I think we've addressed all the questions online, but we'll review those. And if we haven't, we'll pop responses in. But otherwise, just thank you. Travel safely for those here. And yeah, wishing everyone a very good next few months until we see you again. Cheers. Guys, for those of you in person, please feel free to have some small to deliver. But thanks so much for coming through.
Are you off?